Good morning, everyone, and a warm welcome to today's webinar, 4 million people, one crossroads, charting the future of temporary protection. My name is Justyna Segesh-Frelak, and I have the pleasure of moderating today's event on behalf of ICMPD. We believe that this conversation comes at a very crucial moment since Russia's invasion of Ukraine in 2024. More than 4 million people have been displaced across the European Union, deeply affecting those who fled, the host countries, but also Ukraine itself. The EU, as we know, responded quickly by activating Temporary Protection Directive, providing swift and coordinated protection across member states. But while this has been a lifeline for millions, the temporary protection was always meant to be temporary. And with the current extension lasting until March 2026, the question is what comes next and how can the EU best prepare? This is exactly the question that policymakers are facing now. In just over 1 week, EU ministers will meet at the Justice and Home Affairs Council to discuss the future of temporary protection directive, among other issues. That makes, of course, our discussion today very timely. And at ICMPD, we have been engaged in this policy discussions from the very beginning, working closely not only with our member states, but also with Ukrainian diaspora and other key stakeholders. Just 1 week ago, we published the policy paper that outlines the possible ways forward for temporary protection, and we will discuss it further later today. So what will be covered by today's webinar? So over the next 90 minutes, we will take the stock where we stand with the temporary protection today from the policy perspective. We will look into the national approaches and transition strategies that are already underway. And finally, we will also look ahead at policy options, policy choices that are currently on the table, as well as possible implications. So today we are joined by excellent panel of experts from government, civil society, and academia who will bring the diverse perspective on this complex and evolving team. So today I'm pleased to welcome Kamil Kisiel, Deputy Director at the Department for International Affairs and Migration at the Polish Ministry of Interior and Administration. We are really grateful that you could join us today, especially considering how busy you are as the Polish presidency enters its final months. A quick reminder from my side, the temporary protection has been one of the key priorities for the Polish presidency, and we are very keen to hear more about it from you. So welcome, Kamil. I'm also delighted to introduce Meltem İneli Ciğer, Associate Professor of International Law at the Süleyman Demirel University. Meltem has been an important voice when it comes to academic debate around temporary protection, contributing not only to our understanding of EU, but also Turkish frameworks. I would like to welcome Josefine Liebl, Head of Advocacy at the European Council on Refuge and Exile, ECRE. ECRE is an umbrella organization of more than 100 civil society organizations. You've been also actively engaged in the policy discussions together with your member states. Last year, you published your own paper on the temporary protection, and I will return to that and your recommendations in a while. And finally, my colleague, Martin Wagner, Senior Policy Advisor for Asylum at ICMPD. Martin leads our own work on the temporary protection. He has been also engaged in numerous and continuous discussions with our close partners. A small announcement here, Martin co-authored the policy paper that I mentioned, and we'll present the key suggestions from ICMPD side. But before we start, I have a couple of remarks regarding the format. So our conversation today is structured around two blocks of questions. So first we will discuss national developments, the broader context around temporary protection. And then in the second round, we will move to the diverse and possible EU-wide approaches and policy options for the future. Then we will open the floor for questions and answer sessions. So you are welcome to submit your questions at any time during our webinar. To do so, you have to go to the apps button in the bottom right corner of the Windows WebEx window, and you will see Slido that you have to click and type your question before sending it. So we will do, of course, our best to answer as many questions as possible during this session. If time allows, we will wrap up the webinar with final round of comments from our speakers before wrapping up around 12 o'clock. This webinar is recorded, and we will share the link to our YouTube channel in a couple of days. My final comment regarding the report, so you can access it in the content folder. To do so, simply click three dots next to the chat button in the bottom right corner. So let's now move to the first discussion round, and I will turn first to you, Meltem, to set the stage for our conversation. So you've been following the development of temporary protection very closely, from its early days in Turkey to quite recent application in the EU context. So please get us started. And can you explain what temporary protection is meant to do, meant to achieve, and why it has been so difficult to bring it to an end, not only in European context, actually? The floor is yours.
Thank you very much, Justyna. It's a pleasure to be part of this important discussion. To set the stage, let me begin by briefly unpacking what we mean by temporary protection. Temporary protection is essentially an umbrella term used to describe time-limited protection mechanisms that are activated, invoked in exceptional circumstances, in crisis situations, typically in response to a mass influx of displaced persons. These mass influxations are triggered by events that force large groups to flee across borders. This is usually international or non-international armed conflict, or generalized violence, and in some cases around the world, we see temporary protection is even invoked to respond to large-scale displacement caused by environmental disasters. We have seen examples of this in Turkey's response to more than 3 million Syrians' temporary protection, and more recently in the EU's response to Ukrainians fleeing the full-scale Russian invasion. Now, when we look at temporary protection regimes, we see they are typically designed to serve two main functions. First, they are emergency tools. They allow states to react quickly and pragmatically to large-scale arrivals of displaced persons, especially when regular individual-based asylum processing becomes unviable or national asylum systems become overwhelmed. So instead of requiring individual status or protection status determinations, which are usually in massive fluctuations, time-consuming or resource-intensive, in massive fluctuations, temporary protection grants status on a group basis, often based on nationality. This approach, of course, benefits both the displaced population since it gives immediate access to a legal status and rights attached to it, but it is also beneficial for the host states since it does not overwhelm their asylum capacities. The activation of the temporary protection in the European Union provided quick access to resident permits, work, education, and basic services associated with the temporary protection status, without overwhelming national asylum systems of the member states. And this was, as you also mentioned, the clearly right thing to do. However, the challenge with temporary protection regimes is not in their initial activation usually, although it took 2 decades for the Temporary Protection Directive to be activated in the European Union, but in how they end. There is usually an underlying assumption behind activation of the temporary protection framework, and that the conditions causing large-scale displacement will be resolved relatively soon. The expectation is that majority of those granted temporary protection will return home voluntarily and safely when the crisis subsides. But as we know, this rarely aligns with reality. Conflicts today are often protracted, whether civil wars or interstate wars. This situation can last for years and unfortunately even decades. Durable peace agreements are rare, and conditions for large-scale, safe and dignified return often do not materialize quickly, if at all. This is precisely why we are witnessing now with the EU's temporary protection of Ukrainians. More than 4.2 million Ukrainians have been living under temporary protection status in the European Union for over 3 years, and unfortunately there is still no realistic end in sight to Russia's full-scale invasion. This raises a difficult question. How long can temporary last? The Temporary Protection Directive has already been extended multiple times, and there is no clear exit strategy yet. Without clarity on what comes next, temporary protection becomes an open-ended limbo. While temporary protection is a crucial tool for immediate response to crisis and large-scale displacement, it often falls short when displacement becomes. And that tension between temporary nature of the temporary protection regimes and the enduring nature of displacement is one of the biggest policy and legal challenges that the EU must now confront. If return is not a feasible and lawful option, as it is the case with the Ukrainian displacement due to ongoing hostilities, then we are left with one remaining durable pathway, and that is integration. And this also brings us to a key challenge in the extension of temporary protection regimes. The longer displaced people, whether refugees or migrants, all human beings remain outside their country of origin, the more they begin to integrate to the host societies. And this is entirely natural and humane. Over time, people find work, learn their language, send their children to school, build social networks in the host states. With each passing year, the prospect of return, especially voluntary return, becomes more remote, not just legally or logistically, but also emotionally and socially. Also, bear in mind, in many member states, staying lawfully for more than 3 years naturally results in access to various long-term resident permits, or in some member states, even citizenship when additional conditions present. Excluding 4.2 million people from these more durable legal pathways just because they remain under temporary protection status is also not reasonable. The human reality of integrating to the host societies through time must be acknowledged when extending temporary protection and, crucially, when designing what comes next. Durable solutions cannot be postponed indefinitely. Therefore, policy responses and legal statuses must evolve alongside the needs and lived experiences of those displaced persons. Temporary protection should not lead to legal limbo. In many ways, activation of the temporary protection was a success, demonstrating solidarity and coordination between member states. But when assessing the success of any protection regime, we must also look beyond this initial response. A truly effective policy is the one that not only addresses the emergency phase, but also provides a clear pathway to durable solutions. Therefore, the transition from temporary protection to long-term integration or other sustainable outcomes is where I believe the real test lies. Thank you.
Thank you very much, Meltem, for this broad overview and highlighting the fact that legal status must evolve with time and situation in order to address the potential limbo situation. So, thank you very much. I will now turn to you, Kamil, and your ministries, not presidencies, hat. So Poland is a special case not only because of the country bordering Ukraine, the country that is one of the major hosting country, but also because it is a front runner when we talk about possible exit strategies. So Poland has opened the possibility to status change already a while ago, and I would like to ask you about the motivations, rationale behind this decision. We would like to hear whether you have some lessons learned from this period already, and whether your experience could actually inform the EU-wide approach. Kamil.
Thank you very much, Justyna, and thank you also for inviting me to this panel. It's a pleasure being here with you all. Thank you, Meltem, for a very well crafted introduction and a lot of good food for thought for us. Indeed, we are at the thresholds of a test now, thinking about starting our reflections on how to transit from temporary protection to more durable solutions to provide the populations of Ukrainian people displaced from Ukraine with legal stay in the European Union, with the possibilities to stay here legally. So yes, we are thinking about that, and indeed in Poland. So I am now in my, as you mentioned, ministerial hat, not in my presidential hat. In Poland, we already had started this reflection quite some time ago about how to allow a smooth channel for a transition from the temporary protection regime for Ukrainian nationals present in Poland already for some time to more durable legal stay outside of the temporary protection regime. And the rationale behind that was basically, and maybe just for context, I need to mention for all the guests that in Poland we do host the second largest population of people displaced from Ukraine in the European Union. It is a little bit below 1 million people. It fluctuates now, so it's between 960,000 and 990,000, and we see some slight changes in this population. So we have been thinking about it because we also try to quite regularly assess the future plans and expectations of Ukrainian refugees present in Poland. We have a quite extensive panel and questionnaire that is being done on a yearly basis by our national bank, quite surprisingly, but they're quite good at doing that kind of research outside of the things that they normally deal with. So it's a pretty good knowledge base for us to reflect on how to channel the population that we have present. And from this research, what we know, what we knew last year, is that 21% of the Ukrainian refugees present in Poland declare already that they are willing, that they do want to stay in Poland for an extended period of time outside of temporary protection. So that is already quite a significant number. And out of the 79% of those who did not declare that they not already declared that they do want to stay, what we see is that the uncertainty about their future and about the possibilities of returning to Ukraine is growing slightly over time. And that does also mean that out of that number, some part will also be willing or will be considering staying in Poland for longer. So that was the key kind of rationale, that we already have a number of people that would like to move to a more durable scheme of legal stay in Poland. And the other, the second kind of part of this rationale is also the kind of reflection on our sides as the governments, and trying to manage our resources most efficiently, and taking into account that we also have a significant level of self-sustainability within our population of Ukrainian refugees, a high proportion of people that are quite well integrated into our labor market, are working, are earning their salaries, and are able to kind of accommodate themselves in Poland pretty well. We kind of figured out that proposing them a transition to a legal stay scheme outside of temporary protection would be also quite beneficial from the point of view of kind of disarming some narratives that we do face from time to time, some anti-Ukrainian narratives about how people are kind of only trying to siphon out resources from the states, the population of refugees that is residing in Poland, which is not true. I mean, objectively, it's certainly not true. The benefits for our economy are high enough to balance the cost of temporary protection in Poland. But these two kind of strands of reflection led us to actually last year in May to proposing a possibility to transit for a legal stay based on a 3-year residence permit. And the scheme is quite universal. So the only condition that applies to receive that permit, to get it, is that a person needs to be present in Poland for 1 year without any breaks. And the other condition is that a person needed to be present in Poland in March last year and at the time of applying for this residence permit, residence card. So it's a quite simplified procedure. Although it hasn't been activated as of yet, we are still waiting. There is one puzzle missing for activation, and that puzzle is the IT system that would allow us to process larger numbers of applications at one time. And we are still working on that. The legal framework for this IT system is almost ready to provide for receiving applications by our regional governments who are responsible for processing these applications, the voivodeship offices, as we call them, to allow them to process larger numbers. So we have the legal framework now almost ready, should be adopted pretty soon, and we will need to do some adjustments to their IT systems, and everything hopefully should be ready by autumn this year. So we will be ready with we'll be ready to activate this scheme and to allow for this transition based on this quite specific permit that is outside of the normal legal permits that we have available. So that's basically it. And if you're asking whether the European Union can learn somewhat from that experience, I think certainly yes. From our discussions that we held already in the framework of the Council, I can say that member states are somewhat reluctant to propose that kind of specific schemes for transition for the Ukrainian refugees. But we'll see, and I believe that is something to say in the second part of the panel, so I'm not going to go into details on the exit strategies on the European level that we have been working on, and we'll see some effects of that in the coming days. So for now, I think that's it on the transition scheme on our side. Thank you.
Thank you very much, Kamil. And I think that the Polish approach, although still not like operating, is special because of this universal, as you called it, access. Because what we observe, and I'm sure Josefina, you will talk about that more, is that in member states that started offering such pathways, they are usually limited to those who are in employment or are independent. So then this is special that in Poland this will be open for everyone. You also mentioned the need to prepare the IT system in order to be able to process, let's say, million or less, but still huge number of applications. So it's an important point regarding the capacities of the state to plan such a transition. Thank you very much, and for sure we will return to your EU presidential hat in a moment. Josephine, so you and your network of organizations, you are super close to everything that is happening on the ground in the EU member states. So how, according to your knowledge, how are such national residency programs or plans for people under temporary protection are being perceived, discussed by authorities, but also how are they seen by displaced people themselves? Because here the important tension to mention is, of course, on one hand, the quite generous offer of rights under temporary protection and lack of long-term security. You have also other tensions, like this generous rights under TP, but also potentially less rights under the regular permit. If you could elaborate a bit about that.
Thank you very much also for the invitation to this interesting webinar and for those questions. So generally, just to underline that we think it's very positive that countries start considering and have given access to national residence permits to beneficiaries of temporary protection. But it is very important to underline, coming after Kamil and the Polish example, that in the majority of country cases that we are aware of, there are no special schemes that are being developed. Rather, what we see is that beneficiaries for temporary protection are able to access residence permits that usually are connected to an employment situation, but can also be connected sometimes to education. So there's no special or eased access for the group of beneficiaries of temporary protection. And what that means is that while in theory this opportunity exists, in practice it is actually only an option or applicable to a smaller group. of people. So taking, for instance, Germany as an example, where this option also exists, in data from last year, we see that only 3.4% of beneficiaries of temporary protection have switched to other residence permits, be they for work or study or training. And that has largely to do with unmet legal requirements in their cases. They weren't able to fulfill all the requirements that are connected to these residence permits. And this chimes very much with work that ECRA has done in trying to compare the access to all the various socio and economic rights that temporary protection beneficiaries have access to across different European countries. Because you mentioned, of course, temporary protection, one of the reasons why it is so beneficial and was is such a positive status, especially initially, because it gives direct access to rights, to employment, to housing. And that overall is, of course, incredibly positive, but it does not mean that it's not in practice still difficult for people to actually make use of that and realize those rights. And what we found in a comparative report that we have published last year based on data we collected within the AIDA database is that the various administrative barriers related to accessing employment still holds for people who have temporary protection status. That includes recognition of qualifications, language barriers, restrictions to access certain occupations, and an overall lack of information on how to deal with the procedures in the different countries. Thus, while it remains or is an option for some people who are currently beneficiaries of temporary protection, and that is very positive, it is not a widely available possibility at the moment. And this brings me to a point that ECRA has made in the paper that you already mentioned, kindly mentioned in the introduction about the exit strategy and the various options that are available. That one of the many arguments that we're making in this paper is the importance to maintain a range of options available in parallel during this phase of exiting from temporary protection. This will allow the people themselves to make choices that are most suitable to them and that also correspond to their situation. And it's also most realistic in corresponding to the really quite diverse group of people that are currently receiving temporary protection. Maintaining these various options also means that includes access to asylum. Meltem has very, succinctly explained the link between temporary protection and asylum and why it was triggered, and the idea behind, of course, ensuring that the asylum systems are not overloaded. At the same time, of course, access to asylum continues to be an option that is that has to be available for a group of people who are currently enjoying the status. Since 2022, we have seen an increase in asylum applications from Ukraine at a very high protection rate. In 2024, we see that citizens from Ukraine were the main nationality of asylum seekers in 4 member states, including Poland, but also Estonia, France. And in the first months of this year, we saw quite a significant increase in applications for asylum compared to the last year. The overall recognition rate remains high at around 80%. While we see this, there's still a case in certain member states where they continue to suspend the assessment of asylum applications until after temporary protection has ceased to exist. And we are quite critical of this position. In the beginning, probably that made sense for the reasons that Meltem, or that might have made sense for the reasons that Meltem has outlined. Now we think this is, there's much more shaky ground in terms of the argumentation here. The countries that, for instance, are currently not are registering applications but not assessing them are the Netherlands, Germany, and Italy. And in Sweden, beneficiaries of temporary protection have access to an assessment of refugee status, but not of subsidiary protection, which is subject to a preliminary ruling pending in front of the CGU at the moment. There's just as temporary protection beneficiaries, in our point of view, should be able in this transition period or in the move toward an exit strategy, should be able to assess other residence permits, they should also, a group that thinks it is most suitable to them and they have a protection need, should be able to have that assessed. In practice, this might well mean for both cases, residence permit, not protection related, but also protection related claims, that beneficiaries of temporary protection are benefiting from 2 permits at the same time, or are at this currently have temporary protection status and might be in parallel exploring other options. And there we see good practice on how to deal with this situation. For instance, in the Netherlands, beneficiaries of temporary protection can also see whether they are eligible for a regular residence permit if they meet all the requirements. In this situation, should they meet all the requirements, they can hold both permits at the same time. And if there is a case of conflict of rights, the more favorable rule applies. So that we think is a very good practice. And in terms of asylum, we've seen cases such as in France or Romania, where people continue to be beneficiaries of temporary protection during the asylum process. And only once there is a decision, they may switch status to either refugee or subsidiary protection status, or if there's a negative decision, they continue as temporary protection beneficiaries. So that is a bit some of our reflections in terms of how to deal with this potential transition period, and also especially how to ensure that the people have the most options available at this point of uncertainty. And I'll leave it at that. Thank you very much.
Thank you very much for sharing these good practices. I think it's super interesting to hear that some countries allow for two statuses running in parallel, so that this uncertainty can be addressed. But indeed, when it comes to the increases in the applications for protection, what we also observe is that who usually does it is vulnerable groups, people with special needs, because this is one of the strategies of dealing with this temporarity, the insecurity of the future, and we might see even more in case the exit strategies are not in place. Thank you very much, Josefine, and I will now move to ICMPD to talk a bit about our experience gained by convening various policy discussions. So, Martin, based on your experience, on your intel gathered during these consultations, what are the main challenges, the main obstacles that make it so difficult to discuss, design, and finally implement exit strategies from temporary protection?
Yeah, thank you very much, Justina, and yeah, very pleased that we managed to have this group here now to discuss it really as a very timely discussion, to also make a bit sense where we stand and in which direction it could or will go further. And just probably 2 things I see at the end of this round. There were mentioned quite some bits and pieces already, but probably it gives me also some space to summarize this in one way or the other. Probably one comment before. I mean, you mentioned it before, Justina, in the introduction. ICMPD did rather soon started to think about what should come next when temporary protection ends. And in fact, we started actually half a year that temporary protection was in place. And I think it was very much against the background that however we will deal now, whether we still prolong temporary protection, again, at some point it will end, and at some point we will need to think how it goes further. And I think the discussions so far already showed one of the dilemmas that we have in a way, and I would group them in 4 and probably start with the one that was mentioned quite often now already, people concerned. it is not only a very large group, mentioned already more than 4 million. Some countries, like Camille, the case of Poland, around 1 million, more than 1 million in Germany, but Czech Republic with the highest per capita number of applications. And if you just compare here, what it would mean to transit all of those at once. So we come very quickly to the biggest tension, and one of them is for sure capacities, but I come back to that in a second. First, probably still back to the group concerned. It is a very diverse group, and we spoke already that some already transited in one way or the other because they are already in jobs and so on. But very often in these discussions, we also had an opinion that was very clearly saying, I'm not, this was one policymaker in this case, he said, basically, I'm not so worried about those in employment. I'm worried about those who are not able to get in employment. And this can be vulnerable groups. This can be also people who care for others, children, elderly, and so on. They don't have the possibility to do language classes, to enter the job market. And I think Josefina also already mentioned the hardly people enter according to their qualifications, but far below that. So we have this kind of thing that we have some have access to the labor market, some not. The question is really how can we concentrate on those who are not in employment. And there we also see if you are in employment and this is connected to temporary protection, it is also very much to see that who under a temporary scheme who invests in an employee, if it is clear that it might be temporary, but also on the housing market, there are so many challenges with this temporariness at hand. So this is, I would say, these are about the people concerned. My second point that is very much connected to that is, let's call it administrative capacities. And I think Camille already mentioned this in a way that Poland also used this kind of strategy now, because it also would not necessarily mean to have very high administrative burdens in order to determine whether, you said now 1 year presence, this is somehow to manage to take into account if you have other thresholds that must be met, a certain income, a certain time of employment plus a certain time. So it gets more and more complex and more difficult, which then also needs, of course, some administrative determination process where we are actually again at the point what we wanted to avoid through the temporary protection scheme. And we looked in one earlier paper that we also published some I think 1 year ago or something. We compared a bit the numbers in the different member states and what kind and how many people in the international protection process are being processed per year or administered with regards to residence permits. And we saw if temporary protection would end and all would enter into asylum lane or regular migration lane, this would really overstretch administrative capacities by far. And then with administrative capacities, I would not only think here about EU member states, but also about Ukraine. If we go into the direction of return options and voluntary possibilities to return, also this is also not an easy one by far. There, of course, there are some territories currently occupied. Nobody knows what will be there, but also with regard to infrastructure that is partly damaged and so on and so forth. And now actually the one that I had at first point is, of course, and Meltem already brought this up at the very beginning. Yeah, the main thing is the uncertain future. Will there be war? Will the war end? If the war ends, under what conditions will it end? Would an end of war make it safe to return? And if I speak here about safety and security, I don't mean only the physical safety, but I mean actually very much also the broader picture, livelihood possibilities, infrastructure, as I mentioned, access to school, our schools operating, and of course jobs. So, and then I would like to just add one fourth comment, and also a bit connecting pieces from Meltem and from Josefina. That's the instrument itself, the Temporary Protection Instrument. So Meltem already said, the instrument says how we enter jointly, but it doesn't say how we exit jointly. But actually it says we don't exit jointly, we end temporary protection, and it's upon member states. This is all what the directive gives here. So this is not in the directive, and therefore, yeah, we need to think something, because if we in the future will look back how temporary protection was a success or not, I think it will be very much measured in how we exited at the end of the day, and not how we entered it, which was good enough, I must say, but still then it's also to be an appropriate way out of it. And my last point on the instrument itself, and basically the Temporary Protection Directive has three options: return, if possible, then the asylum, or the legal framework that Josefina also mentioned before. And I think it is from discussions, there's quite little wish to change to international protection from member state side, for the said reasons. This was the reason why we entered temporary protection, to avoid it, to avoid overstretched administrations. And actually, there's also quite little wish to a new legislative file, but I guess we will hear more from Camille there. And I would say this is against quite a fatigue on the negotiation side, after long negotiations on the pact, on asylum and migration, but also there are some other files still pending at the moment, return regulation, and so on and so forth. So I think so the room for maneuver is actually smaller than one might think, I would say. So I think this was basically the 4 points that I could see that were already raised, but just to summarize it in a way.
Thank you very much, Martin. For us, it's also equally important to discuss these solutions in between. If we assume that return is possible, then what happens with this group? To what extent there is an appetite for any circular schemes, temporary migration, to allow people really to see whether conditions are there to move back, or actually to live in two countries for a while before taking the final decision. For us, this is the equally important policy consideration for the future. Thank you very much for all your comments. We are a bit late, so let's move now immediately to the second round. And I'm sorry, I will not be very diplomatic, a host or a good host, because I will give floor again to Martin to actually kick us off when it comes to the EU-wide policy options that are available. So Martin, please walk us briefly through the approaches that you identified, but also the pros and cons of each policy choice that you discussed in the paper.
Yeah, indeed. Back I am here. I will try to make it as brief as possible. I think we will also share the link to the paper, that you can also see it a bit more in detail. Just to outline the background of it. The paper was part of a project funded by the German BAMF and AMIF. So it was part of a broader project that actually deals with that actually funds consultation centers in Germany, but also Prague and Poland. And one part was also this policy level that we tried to bring in. We thought it would be good to have a bit of a an outline of what actually are the policy options that are there. They are very often discussed. We could transit into some permits that are there, like long-term residence directive. We could move, we already spoke to international protection, and so on and so forth. So I would just like to share very briefly my screen, and I hope you see it, because it's probably a bit easier to visualize like that. So I think that the considerations were simply there are two major options. On the one side, to continue with temporary protection or to end temporary protection. This is on the y-axis. You see that. On the other side, we have also the possibility to have a new instrument or not a new instrument. And according to these two lines, we kind of discussed in several rounds with member states, but also other stakeholders, various options. And I will just run quite briefly through them, just to have some food for thought, I would say. So probably when we look at the upper left side, so this is option one, yes, this would be the most pragmatic approach here to continue temporary protection. We had it already, a fourth year. Meltem already alluded to it, not undisputed, but we prolonged it. It's very pragmatic, and there would be the administrative burden very low. All people, nobody would fall out of the cracks because all who are currently covered would be still covered. Option two could be also smaller, that the group that is covered right now on a temporary protection could get also smaller. So a few examples we already mentioned. There could be those who already transited international status could be excluded in there. One could also think to exclude newcomers because they could still go, as Josefina said, into the international protection process. So this is also a possibility to narrow down the scope, and also to make it possible that people move out of this temporary scheme. If we go down to the bottom left, right, option 3. So this would be then a new instrument that would actually replace temporary protection. This can be just a soft law. So again, keep it to member states according to the national legislation, but give some guidance in form of a soft law. But it can be also replaced by something temporal. There was one comment by Mr. Usher to have some kind of transition permit. He called it reconstruction permit, to stay for a longer period of time after temporary protection ends, with the option to return. This is also a possibility. The legal basis would need to be found, I guess, but this is also an option. Then there is this hybrid approach. This is on the upper right side, where we would have something between prolonging temporary protection plus some flanking measures. So temporary protection in such scenarios could be there for as a safeguard net for those who cannot transit out of the temporary protection scheme to any national permit. So there could be a combination, so have prolonged temporary protection, but probably by, let's say, a non-binding EU instrument, by a recommendation or something like this, in order to for example, say that member states should harmonize the measures when somebody can access a national permit. So there can be parameters like the length of stay, the length of employment, but there can be also other thoughts there. And the benefit here would be, as I said, the safety net would be there, but we also would start to gradually move people out of temporary protection, so that we don't have the situation when temporary protection ends that everybody at once would move into whatever national scheme there would be. And finally, option 7. Yes, it is also an option that there's simply nothing, to do nothing, to lay back and let the directive do what the directive proposes. Each member states can choose their own scheme, how to transit and how to arrange what happens after March 26 or whenever temporary protection ends. I think here the pitfalls are, I would say, the most here, and we would see fragmentation. This fragmentation means automatically that we would have different standards in different countries. It was a bit what Josefina also mentioned before, and there could be then, yes, there could be secondary movements that people would actually look from one to the other. So I think this last option is something that is the least attractive, and to my point, also not necessarily one that is very favorable. I will stop sharing. I just tried to picture this out very briefly. What kind of options are there? The instruments that were discussed, there are a number of ideas floating around, but I think this could be packed in this kind of things. But I think the most important is, I think, the discussion to do something. And I think the least, what I think is to just rely on temporary protection prolongation and wait, and then 6 months before start panicking again. And I think we heard this from several speakers already before. The uncertainty among the community is high, and we see it also in consultation centers that the closer we come to an end date, the more questions come. And I think certainty is the most important one. I would keep it here, and yeah, thank you.
Thank you very much, Martin. I think it's not only important to do something, but to act early enough and to act actually now. I think we have a lot of good practices or various approaches already taking place, and there is a space to learn from each other. When it comes to, I think it was like option 2, continued temporary protection, fewer people, we observe it also, not among EU member states, but for example in Norway, that introduced this geographical limitation for certain people coming from certain regions. They are not eligible for TP, they are eligible for protection. So I think we will see in the near future more diverse approaches in this regard. Meltem, I would like to continue with you. As an academic, you are not limited by political achievable, by politically feasible solutions. You can have a more ideal, more long-term perspective already in your introductory intervention, but also in your previous comments. You are not in front of the option 1, meaning the continued prolongation, continued temporarity. So if you could explain a bit more, what would be your ideal option for the future?
Thank you, Justyna. Well, as someone, I have worked on temporary protection for over a decade, and not just in the EU context, but I have looked at how time-limited protection statuses in the United States, Australia, South Africa, and Southeast Asia, besides from Turkey. I have observed a consistent pattern across jurisdiction. Temporary protection, by its very nature, it should be time-limited, but it rarely does. So in practice, we see very prolonged temporary protection regimes. We see, for instance, in Turkey, temporary protection of Syrians began in 2011, and it's on its 14th year. In the United States, there is a time-limited protection status called the Temporary Protected Status, TPS. Although it's not attached to a mass influx situation, it has been going on for some Latin American nationals for 20 years. And my argument from all these examples, and in South Africa, Zimbabweans receive temporary protection for nearly 20 years, then they are asked to return back to their countries. And for me, this is a very bad practice. So I want to reiterate that temporary protection must be time-bound, and it should be limited to a reasonable time limit. Now, as an academic of both international and EU law, we know that there is no international convention limiting the temporary protection, how long it can continue. But we know that any derogation from the 1951 Refugee Convention, which suspends individual status determination procedures, must be necessary and proportionate. To ensure respect for proportionality and necessity, in the EU law, we do have a clear legal framework, which is the Temporary Protection Directive. We all know it. But under Article 4 of the directive, when you read both the first and second paragraph together, temporary protection can actually be extended up to a maximum of 3 years. And there is no ambiguity here. While the European Commission and the Council have continued the extensions with the application of the directive annually, there is no legal basis, in my opinion, for going beyond that 3-year maximum. And this is not just my academic view. I have discussed this with many EU law scholars and academics working in the field, and there is no prevailing legal opinion, certainly none among the established EU law academics, that supports extending the Temporary Protection Directive beyond 3 years. So I was really genuinely surprised when the Commission and the Council decided to prolong it to 2026. And it seems very likely, as we all know, that the GAH Council in June will approve yet another extension. Now, from my perspective, this is really legally questionable and politically dangerous. Why? In my view, the decision to prolong the application of the TPD beyond the clear time limit set in Article 4 has not been adequately justified in legal terms. When you look at the Council's implementing decision extending the temporary protection regime, or I have been in various webinars, conferences, and meetings where I have attended alongside the Commission representatives who were present, and there has been little to no serious explanation of the legal rationale behind the extension of the temporary protection beyond 3 years. In my understanding, this risks setting a dangerous precedent, not just for the Temporary Protection Directive, but for any emergency regime that involves derogation from ordinary legal standards under EU and international law. My argument and my logic is that if the EU institutions feel authorized to exceed clearly defined time limits in their own instrument, what is to stop future extensions of derogation regimes under EU law? We know the crisis and force majeure regulation, for instance, will enter in force in the coming years. So who can say when the crisis regulation enters in force, derogation measures will only continue for a year? If we normalize now the indefinite extension of exceptional regimes, how can we ensure that safeguards, accountability, and the principle of proportionality are preserved in the future? Now, to be clear, I understand the continued protection of Ukrainians is both necessary and welcome. No one is arguing against the need for protection of Ukrainians, but it is precisely because of the protection needs are ongoing that we must shift the discussion to what comes next. If temporary protection cannot lawfully be extended any further, we must start designing durable legal pathways, whether that long-term residency, refugee status, or a new rights-based transitional framework. As you mentioned, Justyna, circular migration frameworks have been proposed before in response to the Ukrainian displacement. Kamil has just mentioned such transition is necessary, and Poland is taking measures for giving access to more durable residency options for Ukrainians, and this is a very good initiative. This is very welcome, but at the same time, I think to avoid secondary movements and divergences between member states in the future, there is a need for an EU-led approach and unified strategies to what comes next. Now, from Day one, I have argued that long-term residence directive should be amended to include temporary protection beneficiaries to its scope, and time spent on temporary protection as part of the required 5 years should be valid. I am still behind this argument. I think it is crucial for those Ukrainians that wish to stay in the EU. There's an EU-wide instrument available that leads to long-term residency. We have seen proposal from the Commission, but unfortunately this didn't result in the adoption of the amended long-term residence directive. But we all know, as Martin and Josephine mentioned, even if such an amendment of the long-term residence directive is made, there will be the ones who may not fulfill the conditions for the long-term residence status. For instance, those women with care responsibilities or vulnerable groups that will still need social assistance. I think it is crucial that residency options are available in an EU-wide manner and unified manner for that sense, but others who cannot qualify for these residency options receive the necessary assistance and protection via international protection statuses or other flexible options. Now, coming back to your question, Justyna, emergency measures, in my opinion, such as temporary protection, are by definition not meant to last forever. That is the reason I'm not actually in favor of prolongation of the temporary protection activation for further years. We have seen the results of very long temporary protection regimes, and these results are counterproductive of the initial successes of the temporary protection framework's activation. So stretching temporary protection beyond their legal limits not only undermines, in my opinion, the legal framework we operate within, but also erodes trust in EU institutions and their commitment to rule of law. Thank you.
Thank you very much, Meltem, for this call for a joint action. We can only agree. Also, when we, as you mentioned at the beginning, when we see what might happen with people and their lives when there is a political wind that is changing, and it's enough to look at the US and announcement to close the programs, to end them, and then if people lived somewhere for 20 years, then it's a life tragedy. Thank you very much. I will now move to you, Josefine, and come back for a second to the report and recommendations you proposed last year. So in your paper, you listed 4 important principles that should guide the development of exit strategies. You mentioned already one during your previous intervention, namely the need to maintain a range of options. But in the paper, you also highlighted the importance of keeping up a Ukrainian perspective here, striving for an EU approach that Meltem underlined just a second ago, and the respect for human rights. So from all the options that Martin presented that are now being discussed, from the ECRE point of view, what would be the closest to fulfill all the principles that you listed?
Thank you very much also for Martin for setting out these various options so clearly. So I think we probably are all agreed, or we at least quite strongly agrees with the suggestion that the do-nothing approach is clearly the worst one of all of the options on the table. The disadvantages Martin already alluded to, they're even more in the paper. I just wanted to underline from our perspective the risk of a potential race to the bottom in terms of rights being awarded to people is real. It would be, we think, incredibly divisive amongst EU member states, or could turn this issue, which is not yet divisive, into one of the divisive questions in relation to asylum, and that not apart from the impact that it will have on the rights of people concerned, the possibility for this division to be exploited by the government of Russia and other anti-EU forces is, I think, also a real one. So the worst case scenario is clear. Then in an ideal world, the ideal scenario in our perspective would be closer to the innovative approach, where sustainable replaces temporary and there's binding EU framework. That would probably correspond most to our principles. At the same time, we're not suggesting that because we are aware of the political environment in which we operate. And we know that given the current dynamics discussions in the Council as well as the European Parliament, any kind of new proposal, I mean, firstly, there's really no appetite, but any kind of new proposal that would be negotiated would not lead to a progressive rights-based future for the people concerned, unfortunately. So we probably find ourselves in a situation where, and particularly in light of our preference and one of the principles of maintaining various options, is probably some kind of mix of these hybrid approaches that Martin explained to us. And there we have a couple of, I guess, caveats or considerations just to add to the discussion. The first one is that a significant risk with those 2 hybrid scenarios that were mentioned is that it particularly traps the vulnerable people in the situation of temporariness. Whilst the other ones, and I think that alludes a bit to what you mentioned, Martin, before, that someone from a member state said, I'm not so worried about the people who can access employment because they are in a way on their way towards self-sufficiency and permanent residence. It is the people who, for various reasons, will not be able to access this, that we should be thinking much more about. And in these hybrid scenarios, as far as I understood, those are the ones who would continue in the temporary status for longer and making them even more vulnerable. And I think that's where we need to find ways, or that's where the focus of the discussion should be, or more considerations should be done. Then something to echo something that Malcolm has said, while we of course, don't advise to launch into negotiations of a new instrument, there are existing instruments that are under negotiation that can be amended in a way so that they fit the situation, and that is the long-term residence directive. And whilst that's not how the Commission proposed it in the European Parliament's position or in reiterations of it, they were their approach was to make sure that beneficiaries of temporary protection would fit within to the scope of long-term residence directive. So I think that is something that we would want to push for and are arguing for. And then what continues from our perspective is the preference for binding EU law over soft law and guidance. And that is not, if I can say it like that we have any hopes that the European Commission will in the future change its approach in terms of enforcing EU law when member states do not apply it. We don't necessarily see that this might change. But it really matters for the people concerned and the litigation that we see that is underway in a variety of different member states in relation to their status. We see that with temporary protection, where there's a lot more requests from lawyers we work with about their status and about the possibility to also access other statuses. But anything that is firmly in the soft law requirement would, of course, have an impact on the way in which people who are affected can actually access these rights. And I will leave it at that. Thank you.
Thank you. Thank you very much, Josefina. I think it's like many points to next week council meeting and future presidencies, I suppose. So, Kamil, last but not least, we would now turn to you before we move to the question and answer session. So, with the council meeting approaching, we are of course very curious to hear more from you, to the extent you are able to share how the conversation is shaping up behind the scenes. Are there any particular opinions, ideas that are getting traction? And finally, what is the Polish presidency strategy for what should come after March 2026?
Thank you very much, Justyna. I will gladly share everything that I can share. Being just before the JHA Council meeting that is scheduled for the 13th of June. And already we are in the midst of preparing the package on temporary protection that will be under discussion during this council. Maybe just for a very brief introduction, I can mention that, and referring to your question on the Polish strategy, we have already fulfilled the majority of the milestones that we have planned within what we can call or frame as a Polish strategy for dealing with the future of temporary protection. So we did manage to hold a number of discussions on working and strategic level in the council, and we've used the working parties, the asylum working party, the legal migration working party that is called IMEX admission. We've used the SKIFA strategic committee for Immigration, Frontiers and Asylum. For that is a higher level party in the council dealing with more strategic areas and cases and questions. And based on these discussions, the results of these discussions, we fed to the European Commission, that is, of course, responsible, that has the legislative initiative in the European Union, is responsible for preparing any proposals to be adopted by the Council at the end of the day. And what we can tell, what we see from these discussions, because we did identify a number of areas of convergence between the member states. And firstly, the first kind of area in which member states were relatively in line was that situation in Ukraine remains volatile and unpredictable still, regardless of the processes that have been initiated that may or may not lead to a more sustainable peace in Ukraine, a ceasefire, and so on. We need to take into account that they may fail and the situation may still deteriorate, and it would be too early at this point in time to lift temporary protection. But of that, we are absolutely certain among the member states. And that, of course, led us to the conclusion that temporary protection should be prolonged for another year. And on that, member states are also pretty much in line. Based on that, the European Commission will most certainly provide us with a proposal for prolongation of temporary protection. So with another Council decision that will prolong temporary protection until March 2027 without any significant changes. We have taken into account, and we have been discussing any potential limitations of the scope of this decision that that is in force, although that didn't gain much traction among the member states. And we've also came to a conclusion that trying to diversify temporary protection based on geographic regions in Ukraine, that would require the amount of administrative capacity and would require individual assessment in each case. And frankly speaking, would also be susceptible to circumventing quite easily on the side of potential beneficiaries of Ukraine, of temporary protection, that would like to circumvent that. So we figured that it would be counterproductive to introduce that kind of limitation. We have been wondering also, then discussing limiting the scope and seizing temporary protection for newcomers, but again, taking into account the situation in Ukraine. That didn't gain much traction at this point in time as well. So keeping in mind that, of course, temporary protection is in place until the conditions in Ukraine are in place, the conditions that triggered temporary protection in the first place. And temporary protection can be lifted with a decision by the Council at any point in time. There is still space for prolonging it for another year to provide more certainty to the refugee populations, Ukrainian refugee populations that are present in the European Union, and to be ready for any potential additional inflow that hopefully will not occur. But again, the unpredictability level is still quite high on that. The other area of convergence when it comes to possible exit strategies, because that have been quite extensively under discussion within the Council already as well. And the area of convergence is that firstly, member states would certainly, and that has been mentioned a couple of times by both Meltem and Josephine and Martin, member states would like to avoid overburdening their asylum systems. That's something that they have been very, very vocal about. And certainly it is true that temporary protection is in place for that reason as well, to avoid this overburdening and overstretching national capacities when it comes to asylum systems that in many member states are already stretched to the limits due to refugee inflows from other geographical areas. So that was pretty clear for us, and the next thing that we've identified and on which member states agreed on to a large extent was that when transiting beyond temporary protection, transiting for to more sustainable solutions and providing opportunities also for sustainable returns, the approach needs to be coordinated on EU level. And of course, the rationale for that is to provide a more or less same conditions for that transition to Ukrainian populations in various member states, but also to avoid any kind of transition measure shopping, as I can call that, and to avoid a significant increase in secondary movements of beneficiaries of temporary protection between the member states due to differences in approach when it comes to exit strategies. It's kind of, I don't know if it's saddening, because some of you mentioned that the do nothing approach would be the least favorable, which is of course true, and a degree of coordination is certainly would be very much appreciated by the member states, and that is something that we will strive to achieve. But a EU level kind of legal solution, any legal intervention, has been largely discarded by the member states at this point in time for various reasons. Firstly, for the reason that the time frame is somewhat limited, even taking into account that we will prolong temporary protection until March 2027. That's when it comes to EU legislative process, that is not that much time, to be honest, to go through a whole new set of regulations that would apply to beneficiaries of temporary protection when it comes to providing them with opportunities to legalize their stay in a more durable way. So that's one thing, and the other thing is, and I think that Josephine already mentioned that we have difficulties with migration files in the Council, with other migration files in the Council, and I think that long-term residence directive is a very good and vivid example of the difficulties, the hindrances that we can face while trying to negotiate a whole new set of regulations. And yes, there is some fatigue after the very lengthy and arduous negotiations of the set of measures that now compose the so-called Pact on Migration and Asylum. That's certainly true. And yes, and you've also very rightfully mentioned that it might be beneficial to inject some solutions for beneficiaries of temporary protection in EU instruments such as the Long-Term Residence Directive. But again, the negotiations on that came to a stalemate largely, and we didn't manage to move forward with this file. I believe that the incoming presidencies, the Danish and the Cyprus presidency, will have same difficulties, and if they wish to try to advance in these negotiations. Yeah, and we will have most certainly by tomorrow from the Commission, we will have a package of instruments, one of them being the already mentioned decision on prolongation of temporary protection, other being a proposal for Council recommendation on the exit strategies. And we'll see about what will be the content of that from our discussions, and then from how I see it at this point in time. I believe that the Commission will provide more of a structure for the Council to still fill in during the normal process of Council negotiations. So certainly no exit strategy will be adopted during the Polish presidency, because we don't have that much time. We will initiate the negotiation process in the Council. We will do as much as we can to fill it with additional content. We'll probe the member states on what are the appetites to have that kind of coordinated solution. but this solution will be based more on national schemes and national opportunities, not on any kind of EU level instrument. And what will be outlined quite strongly is also the coordinated approach to sustainable return and reintegration. And that will be certainly a part of that. I believe the Commission will address information provision and promoting the solutions that are in place, both when it comes to transitioning to legal stay based on national schemes and in the area of sustainable return and reintegration, which will be done, of course, in cooperation with Ukraine, which already promotes their initiatives, such as the unity hubs that gain some traction among the member states. Some of the member states already signed memoranda that regulates the establishment and functioning of such unity hubs. Germany is certainly an example of already operational unity hub, as far as I know. So the cooperation with Ukraine will certainly be a part of these efforts. But again, that will be triggered when the time comes and when conditions in Ukraine allow for safe and sustainable returns, which is not at this point in time. So I don't want to take too much time because I think we are a little bit behind the schedule, and I already see questions popping up in our chats.
Yes.
So I can stop.
Yes, so thank you very much. Maybe we are not yet in the do nothing box, as you mentioned, but still in the pragmatic box with prolongation, but still at least the agreement to coordinate the national approaches to address the potential negative consequences of patchwork approaches. I think it's a good theme for a next meeting, how to really coordinate in the meaningful way among the member states. Please bear with me for 1 minute. There is one question targeted at Poland that is interesting, let's say. It's about the Polish transitioning scheme. Is this something the new Polish president can block? And if he can, will he?
Yes, thank you very much for that question. The short answer would be yes, because it didn't go through the parliament yet, and certainly didn't receive the signature from the president, which is necessary to adopt a legal act in Poland. And to try to answer the second question, I have to say I have no idea, because that is a new president and it's difficult to assess what will be his approach to any questions, any files, any legislative acts related to the presence of temporary protection beneficiaries in Poland. I don't want to prejudge that. I mean, the subject of the long presence of temporary protection beneficiaries did come up during the presidential electoral campaign to some degree. I don't think that it resonated to a degree that would require the president to be very much against. And again, that is something that is designed as a part of the potential transition or exit strategy from temporary protection, and something that's that might save some of the resources that are that we devoted to temporary protection scheme. So I don't know. I believe that certainly we cannot say that yes, the new president will block anything in connection to temporary protection and exit strategies.
Yeah, thank you very much, Kamil. I suggest that we try to very briefly answer 2 more questions that are listed here. The first one is about not leaving anyone behind during the transitions for temporary protection. So how this can be done. Here we have a case of stateless people, but you referred to the people with special needs, vulnerable groups. So maybe Josefine, you can take this one and share what would be the ECRE recommendation in 1-2 sentences, how not to leave anyone behind.
Yeah, I think this is one of the many challenges that we have, and that has come out throughout the discussion. I think this issue of ensuring, even though we understand member states are not in favor of it, but ensuring that people already now have access to asylum. So those who don't currently see themselves reflected in any of the options, and who want to find a way in which they can transition out of this temporariness to have their protection claim assessed, is, in our view, an option. Overall protection rates remain high, refugee status and subsidiary protection. There might also be other national protection statuses that come into play, such as humanitarian related protection status. Although that's overall in Europe on decline, that might also be an option. So that's, I think, all I can say on for this.
Thank you. Thank you very much. And the question on Ukraine, to what extent is Ukraine envisioned to be a part of the discussions on post-TP solutions? Martin, I suppose that's the question for you.
Yeah, I'm not sure whether it's a question to me, but yeah, no, I think Ukraine is in a number of platforms represented, and of course we also saw in our discussion there might be also some challenges here coming up. Ukraine wants clearly people back, needs people back, is a huge loss of people, not only since but already before. There were many people from Ukraine abroad. So there's a number of challenges, because they will also actually need those who are actually currently in employment in member states. They need also those, especially, probably back. So there's quite some tensions open, and the big need to keep them in discussions, and I think it is happening. Probably one small thing, and Camille referred to it. Ukraine is also very active at the moment to promote this Ukraine hubs in several EU countries. They're already advanced to do that, and I think the idea is here also an understanding that there will be some transition period, some transition phase in one or the other. We don't know when temporary protection can end and when people can return. So I think there's also quite a lot initiatives by the Ukrainian government to keep these ties with people abroad, with beneficiaries of temporary protection, but also with diaspora, starting with language, Ukrainian language, to have it for children open, traditions, and so on. But of course also a channel for communication towards Ukrainians abroad. So yes, on various levels, I think there is an involvement, but yeah.
Thank you very much. There is one last question that covers the impact of changes of US approach to refugees in the US. I'm not sure to what extent, Meltem, you can cover that as the one following closely the situation in US in the context of temporary protection.
Well, I can try. I'm not certainly an expert in US law. We know that Trump's policies are very unpredictable. They can happen in a moment, and they may not be in line with international law guarantees that we see. But at the same time, I think it's important, although in the US there is a considerable number of settled Ukrainians. Even before the war, there's a potential for diaspora, and Ukrainians were given access to the TPS status when the war first began. But at the same time, we see, as the comment mentions, that the suspension of certain legal pathways to the US. But it is also important that from resettlement from EU to very popular or large-scale thing, because when we talk about refugee resettlement, we talk about resettlement from least developed or developing states that do not have the capacity to protect the refugees to a more developed state so that they can have a durable solution. And in the EU, we have EU law, and the member states are accepted to have such capacity. So although the US may continue or stop the programs that may enable their legal presence in the US, and this is also depends on which program we talk about, the suspension of certain visas, but at the same time there is no large-scale resettlement program between the EU and the US to my knowledge. I hope
thank you very much, and thank you all for staying with us for a couple of minutes more. So big thanks to all the speakers, to our panelists today for your insights and ideas how to move forward with temporary protection. Thank you for joining us. We will for sure continue the discussions on the future of temporary protection as ICMPD. Thank you very much and enjoy your afternoon.
Thank you very much.
Thank you.
Also,
Thank
congratulations on your paper. I didn't say that.
Thank you.
It will still be used for, I believe, the member states during negotiating the coordinated exit strategy. So
wonderful. Thank you.
Bye.
Bye bye.